finalizes the newsletter, he cross-references the cases he selected with Rafi's posts on X. If there is a case that John didn't put in the newsletter, but Rafi did, John goes back to the case, reads through it, and invariably puts it in the newsletter, except for that one case that you will be discussing today. Rafi is John's backstop, and we can't be happier that he and Zhenya are here with us to celebrate our anniversary. Welcome, both of you. We don't have that much time, so let's jump right in. Eugene, what do you have for us?
So I have Duncan v. Bonta, which may end up just being called Duncan, because it seems like might be the end of the line, or unless the court takes it, but could be called Duncan X, that is to say Duncan 10, as I count it, because there are references to earlier opinions, both at the circuit level and the district court level, up to Duncan 9. So I think this is Duncan 10, unless it's Duncan 11, because of the accompanying set of opinions regarding this weird and bank procedure issue, which I will largely set aside. So it's a case that has a history, and it's a case that unsurprisingly perhaps created a lot of disagreement. It has to do with a California law that bans magazines, gun magazines, that carry more than 10 rounds. The majority, and many others, call them large capacity magazines. The dissents call them standard capacity magazines. They say that these magazines, like 17 rounds, 20 rounds, and such, are actually kind of the norm, especially in the 3/4 of the states that don't regulate magazine size. It's regular for manufacturers of semi-automatic guns to distribute them with these magazines that have that many rounds. But California said, no, you have to cap it at 10 rounds. So this was challenged under the Second Amendment. And of course, in the several years that this case has been going up and down, things have changed in Second Amendment law.
Hi, everyone. Welcome to the anniversary edition of Short Circuit. We are live at the Studio Theater in Washington, D.C. with two amazing guests who need no introduction to the Short Circuit audience. Zhenya Voloch, Rafi Melkonian, and Short Circuit go way back. John Ross first cold emailed Eugene, who is now a distinguished fellow at Hoover, 10 years ago, asking him to post us on Voloch conspiracy. John wasn't sure he would even get a response, but within minutes, there it was. Eugene opening up his large platform for us to spread our word on it. The Voloch conspiracy since moved from the Washington Post to Reason, but he took us with him, and we are very proud to be there. Rafi and Short Circuit also have a long-standing relationship. Till this day, when John Ross...
The current Second Amendment test basically has two parts. First, one is supposed to ask whether the Second Amendment's plain text covers the conduct. And then, if it does, the government must then show that the regulation is consistent with this nation's historical tradition of firearm regulation. So this is sometimes called the text and history test. It's actually quite analogous to the law of many other constitutional provisions: Confrontation Clause, Criminal Jury Trial Clause, Seventh Amendment, Double Jeopardy, and such. It's a highly historical inquiry into late colonial and early American legal practices in all of those areas, on the theory that those were the practices the framers constitutionalized in enacting the Bill of Rights. Of course, it's also quite unlike the way, say, free speech law operates or equal protection law. There, it's a lot less historical, a lot more focused on things like strict scrutiny, intermediate scrutiny, and such. So the majority consists of 7 justices, which is to say the Chief Judge, Murguia, I'm probably not pronouncing that right, Murguia perhaps, Judge Wardlaw, and 5 senior judges, Sidney Thomas, Graber, Paez, Berzon, and Hurwitz. That itself is a matter of some controversy in that accompanying opinion, which I said I won't talk much about, except to say that there's an argument about whether senior judges should be able to sit on an en banc because they had, while active judges, because they'd been on a previous en banc. So now you have a situation where the majority might not represent, or perhaps it does represent, hard to know, the views of the active judges on the court. But let's bracket that for now. They upheld the law, and they concluded that the law could be upheld on one of two theories. They gave both and said, in the alternative. One is that magazines aren't really arms. They're rather accoutrements or accessories. And you might imagine something like that, like you can imagine maybe a strap for holding a rifle. Although, of course, the typical semi-automatic gun won't operate the same way without the magazine. And some of them are even set up with a magazine interlock that keeps them from operating at all without the magazine as a safety feature. So the magazine is a necessary part, but of course, a 17-round magazine or a 20-round magazine isn't necessary. Magazine with some rounds is necessary. And the court acknowledges that magazines, even if you view them as accessories or accoutrements, they're protected by an implicit corollary right to bear the components or accessories necessary for the ordinary functioning of the firearm. But that corollary right only applies to the necessary items. So a ban on guns as such would be a ban on arms, and that would be, at the first step, categorically covered by the Second Amendment, presumptively unconstitutional. But a ban on certain kinds of magazines, well, that's only presumptively unconstitutional if they are necessary to the functioning, and reasonably necessary perhaps, but the court says, look, one rarely needs more than 10 rounds for self-defense, so its minor burden isn't really necessary. In the alternative, the court says, even if such magazines were arms, regulating them is still consistent with a historical tradition. So it points to traditions of restrictions on gunpowder storage, on the theory that that's an early tradition of laws seeking to protect innocent persons from devastating harm by regulating a component necessary to the firing of a firearm. There was accidental harm, not intentional harm, but they say that's a close enough analogy, especially if you couple this with laws that ban, for example, automatic trap guns, or laws that ban weapons that have been found to be dangerous, like lances and pocket pistols, daggers, Bowie knives, and slingshot. I like it because you think it's a slingshot. It's not. It's like a kosh of some sort. Those have little self-defense value, minimum value in self-defense. Likewise, note the analogy to the claim that larger capacity magazines with more than 10 rounds, standard according to the dissent, are not really that necessary, at least marginally, compared to the 10-round ones. Now, one thing that we'll see the dissent talks about is that magazines are very common. And the court had talked about that guns in common use cannot be forbidden, but the majority says, well, that was said in Heller as to handguns, has to be understood in that context. Here, California bans only one type of optional accessory to some firearms, and that's not quite the same as banning something that is in common use, that is an actual arm. So that's the majority. Now, the dissent, let's say the primary dissent, written by Judge Bumate, joined by Judges Ikuda, Ryan Nelson, and Van Dyke, disagreed on all of those facets. First, it said, look, we acknowledge that the court had often said that the Second Amendment only protects weapons that are in common use, as opposed to those that are highly unusual at large, that are dangerous and unusual weapons. But this is extremely common. It says more than 100 million of these magazines exist in the country today by the most conservative estimates. Probably about half of all the magazines in the U.S. They're legal, as I mentioned, in 3/4 of the states. And the dissent says, look, the court has always grouped dangerous and unusual together. It's not enough that they're dangerous. All arms are dangerous. They have to be dangerous and unusual, and these aren't. And that the accoutrements point, it said, look, you look at dictionaries of the era, they suggest it's things that are related perhaps to the military or to weapons, but they don't talk about these kinds of things as accoutrements. So it gives an example from a military dictionary that accoutrements were the things like belts and pouches and cartridge boxes and saddles and bridles and the like. Talked about how they had to be made out of good leather. So in any event, that's the principal dissent. But what I think people are really interested in is the Judge Van Dyke solo dissent. So first, it makes up various arguments about, the chief argument it makes is that under the majority's view, really any part of a gun is going to be viewed as an optional accoutrement because all parts of the gun pretty much can be swapped out. You can replace a trigger with another trigger. You can replace sights with other sights. You can replace a grip with another grip. You can replace a barrel with another barrel. And I think that's quite right. But Judge Van Dyke thought, quite possibly reasonably, that it wasn't enough to tell that he needed to show. So the dissent is accompanied with an 18-minute video of him going through, I'm not sure it's just his own personal gun collection, which may seem large to most of us, but I assure you is small by the standards of some. Maybe he borrowed some from some friends, but he goes and he shows with a few guns how this actually happens. And if you look at the video, it really is a video illustration of what he was saying in the text. And it was really, I think, understandable that might be a valuable feature, but it certainly is unusual. And, judges don't like unusual things. Lawyers don't like unusual things. Maybe people sort of scratch their heads and say, this is very odd. So as a result, the concurrence says this is egregious. He has appointed himself as an expert witness. And that's impermissible. He also talks about where would the videos be stored for later access, how could their contents be searched and cross-referenced. Though note the same thing can be said about pictures that are included in opinions, which is a coming thing. And Judge Van Dyke says, look, there's nothing about the video that specifically shows expertise in this. He says it's not really the expertise requires an expert witness. The text of my opinion says the same things. The majority isn't criticizing, the concurrence isn't criticizing it, presumably because it's quite legitimate for judges to do that, and they shouldn't be criticizing the video. I'm inclined to say that on that expert point, he is probably right. That you can often have expert witnesses on history, but judges often give their own historical analysis, as in fact the majority did. You could have expert witnesses in economics, but of course many judges talk about law and economics, right? You can have experts on corpus linguistics. The concurrence points out that, in fact, one was used in this case. But in fact, some of the earliest corpus linguistics opinions were written by judges who were expert in corpus linguistics, but didn't have to qualify as expert witnesses. You might say it's the same thing about statistics. Interesting question, what about translation? There's an interesting opinion from 100 years ago which involved a punishment for something published in a German language newspaper, where Justice Brandeis basically said, well, this is all from mistranslation. If only the judge and jury had compared the translation to the German original, they would have seen the error, which is funny, but I mean, he spoke German, as I understand it, very well. So I'm inclined to say that that's not impermissible behavior for a judge, although it certainly is unusual and therefore suspicious.
The most disturbing part of the video to me was when he was calling out a lawyer arguing for the government. As he is making this video, they cut to the argument that the lawyer was making and how the judge was pushing back against the lawyer. And so there's a little bit, I know that, people can hear the oral arguments and, they're available to live stream, but there's something really scary about the judge basically cutting straight to you and saying, this is the part that I'm really interested in, what you said, and I wasn't satisfied with your answer. And now it lives forever on YouTube with ads coming near you.
That's the nature of our commercial media.
As a workaday appellate litigator, the big reaction I had is, do I really have to start watching like 3 hours of videos a week when judges make all their dissents and opinions have little video, additions with them, and I don't really care about this video. I think it was illustrative. I enjoyed the AK-47 that was mounted over the judge's desk. But if it became more common, I think that would really be kind of a bad way of doing judicial work, just from the perspective of a regular lawyer.
What did you think about that? So other portions of the opinion, for example, Judge Berzon talking about the problems that she saw.
Well, I could understand why she was so shocked by it. I mean, no one has ever really done that except for Judge Posner. We were talking before this recording about a video Judge Posner from the Seventh Circuit had done about donning and doffing under the Fair Labor Standards Act. So there's one example previously, but
so there's a precedent. Now it's okay.
But generally speaking, judges don't do videos, and I think there's a reasonable, reaction from judges to novelty, and especially to novelty in a case like that. So I was not surprised that the judges found it sort of problematic.
Judge Bumatai also had a table in his dissent, and in that table he compared the previous en banc decision that was GVR'd by the Supreme Court with the decision that they wrote. And he basically said they didn't change anything. What did you think about that? That was a bit of kind of a raw calling out too. It felt kind of edgy.
Well, so that's a separate question. Yeah, there was edginess in all the opinions addressed to each other. It seemed that table seemed totally legit. I think there were some adjectives that were used at times by the judges about the other judges' opinions that struck me as perhaps better avoided in a way that the table did not.
Do you think that the concurrence on the video brought more attention to the video? 277,000 views.
I think it would have gotten plenty of attention without the concurrence. A federal circuit judge making a 20-minute video about his gun collection is unusual enough that I think anyone would have watched that. So,
well, in particular, kind of gun people who are quite active online. I'm sure that's that. I wonder, I should have checked the comments. I wonder how they said, well, you call that a self-defense? You call that a collection? Well.
So what is your verdict overall on the decision? Do you think the United States Supreme Court, if it were to take it up, would have something different to say?
It's hard to say. I've always been sympathetic in some measure to arguments that say, look, you have an important right to bear arms, some other rights as well, but there may be some regulations on it that are permissible so long as they don't excessively burden the exercise of the right. And that limiting magazine size to 10 rounds, I think it's pretty unlikely to do that much good, but probably pretty unlikely to do that much harm, because it is in fact very rare that people do indeed need more than 10 rounds for self-defense. Judge Van Dyke gave an example of an incident where in fact the person defending himself shot off all 10 rounds, needed that many, needed more, and ended up getting very badly injured. Thankfully didn't die because he'd run out of ammo, and he could have had an extra magazine in his pocket. But my sense is, most people would rather not have to, if they have a gun that they're carrying, which I think millions of people do every day, quite routinely. There's a lot of concealed carry, maybe tens of millions, to also have some place to put a spare magazine. So I do think it imposes some burden, but maybe not that great a burden. It might be like the sort of thing that the court upheld in Bruin, where it said, well, if you have some fees and some delay in getting a concealed carry permit, that's okay, because we may need to have a system for making sure you're not a felon or whatever else, beyond perhaps just a standard instant background check. But once it becomes too great, then it becomes unreasonable, and then it needs to be struck down as applied. So it might be that courts say that. At the same time, also Judge Van Dyke again, I think plausibly pointed out, said, okay, California says 10. Well, what if they said 5? What if they said 2? In principle, you could say, well, 2 is generally not enough. 5 may be not enough, but 10 is enough. And you maybe even have something more than just gut feel. You can have statistics, like how many shots are fired in a typical defense scenario, hard to know for sure, but you can estimate it. So maybe courts might apply that properly, but you could certainly see some justices, if they agree to take the case, saying, look, we don't want courts to be in the business of this kind of line drawing. We think that magazines are arms, and as a result, they ought to be protected regardless of the size.
Finally, because we did start as an en banc project, I have to ask you about Judge Nelson's dissent and the issue that he took with that. This case.
It makes my brain hurt. En banc is usually a process that courts use to make sure that individual decisions of 3-judge panels reflect the view of the court, which is to say of the active judges on the court. And that's especially so in a court like Ninth Circuit. I believe it's 29 judges. It's quite possible, statistically it happens quite often, that there are three-judge panels that are pretty far removed from the center of the court on a wide range of possible issues. And the en banc process, which in the Ninth Circuit involves only 11 of the 29, I think it's in theory possible. In fact, I know it's in theory possible to have a super en banc, a true en banc. I just think it's never happened. But the en banc process is supposed to make sure that those can be corrected in ways that bring it closer to the center of the court. For that reason, generally, senior judges are not selected for the en banc court, even though they are quite often selected for panels. Likewise with district judges. But there are rules that say that senior judges can be on the en banc court if they were on the panel, or they could be on an en banc court if they had been while active judges in a previous. Excuse me, I'm sorry, I shouldn't say exactly that. If they were selected for the en banc court while they were active judges. And the question is, can that properly extend the way Ninth Circuit practice seems to have done to people who were as active judges in an en banc years ago, and now this en banc is coming back straight to the en banc court. Itself a controversial issue because some say it should come back to a 3-judge panel first. And then at that point, you see why my brain hurts? Your brains now hurt too. And then at that point, they could end up being, after being senior for 5 years, back on this en banc and have 5 of the 11 judges be senior judges and therefore make the en banc, at least in theory, less representative of the overall court. I'm not sure it's in practice true in this particular situation. But let me just close with a fun fact. District courts can sit en banc too.
That is a fun fact.
It is a fun fact. Most people don't know that. I think Mistretta, remember in the late 1980s, the first challenge to the sentencing guidelines that upheld it against certain objections, even though they were later struck down in large part as to other objections, actually came from a district court en banc hearing. What sometimes the way that it happens is that sometimes judges in a district say, this is an issue that's coming up all the time for all of us. We ought to settle it once and for all for our district. And they can do that. There are no rules that authorize it the way they do in the circuit court because it happens almost never. But apparently they have this inherent power. So that rare bird, the district court en banc.
You heard it here, folks. So now we're going to transition from a case that, shed the light on facts through word and through images to a case that kind of didn't really even discuss facts. That's kind of why we missed it when we were looking at cases to put into the newsletter. Rafi, tell us about Edith Jones's opinion from the Fifth Circuit.
So the case is called Sullivan v. Feldman. It's a published opinion from last week in the Fifth Circuit. It happens to be my case, so I'm talking about it with my client's permission and blessing, but I'm going to try to be as fair as possible to it because the facts are extraordinary, even if you disagree with me entirely about how it should have come out. So it's an astonishing mess that the Fifth Circuit tried to resolve, and I hope they did. So let me give you sort of the capsule of what happened. My client is Mr. Feldman, and he has a series of companies that he more or less controls, and he offers insurance products for various businesses that have tax benefits. A group of doctors hired him to do this work, and in their commercial agreement, there was an arbitration provision. a very common thing to have in a commercial agreement between sophisticated parties. But this was a slightly unusual arbitration provision. What it said is, all the usual things, all disputes between the parties will be resolved by an arbitrator. But then it said, if you don't finish the case within 4 months of it being submitted to you, any party may divest you and submit the case to a new arbitrator. Now, those of you who've done arbitration may be starting to figure out what the problem is, which is that none of these arbitrators finished the job in 4 months. And a series of arbitrators were divested, one after another, to where we had 10 active arbitrators, all of whom rejected the 4-month limitation and proceeded with the arbitrations. We went to a federal district judge in Texas, Southern District of Texas, Lee Rosenthal, so I think many of you will know, very highly respected district judge there. And Judge Rosenthal, for reasons I'm not going to go into now, said 4 of those can proceed. So there was a 4-way simultaneous arbitration on the same topic. The arbitrators rented a room in the most expensive resort in Houston. They heard evidence, and each arbitrator issued different rulings on the evidence that was coming before them. So one would admit a piece of evidence, one would reject it, one would say, I'll deal with it later, whatever. Now, all that was bad enough, but then there was a real divergence in how the case was handled. One of the arbitrators, Mr. Jones, initiated a class action against my clients. The other one, another of the 4, Mr. Glasser, he not only said there was no provision for class arbitration in the arbitration agreement, so in other words, all these other people that weren't parties in the case couldn't come in and litigate, but then he reached out and vacated Mr. Jones's class arbitration. Mr. Jones sanctioned Mr. Glasser and the parties. There was, crosswise sanctioning, and they all proceeded in this preposterous, multi-week, quadruple arbitration. There were 4 arbitration awards that came out of this. The best for my client was a $1.5 million judgment against us. Not judgment, award, with no class arbitration, and as I said, a vacator of the other guy's class arbitration. The worst for us was Mr. Jones's, which was a $90 million award, plus 40-ish from the class, plus fees. And we obviously didn't know what to do. So all the parties ran to the district judge to try to get the one that was favorable to them confirmed, which is what you do with an arbitration award. You go get it confirmed, and it becomes a federal final judgment that can be enforced. So we said Mr. Glasser was very wise and should be confirmed. Our opponents, said Mr. Jones was the right answer. What Judge Rosenthal did is said, look, you wrote this arbitration provision. I am not going to fix it for you. There is no provision in the Federal Arbitration Act that allows me to vacate an arbitration for being sort of ridiculous. It's not one of the enumerated reasons. And so I confirm all of them. So we had a internally inconsistent final judgment, a final judgment that said both X and not X, not just not X, but like X vacates X, not X, right?
What do you tell your clients?
Well, they were the ones telling me. Yeah. My client in this case is a lawyer, so he understood perfectly well what had happened. And he's a very smart lawyer, so he got it. And I told him we will have to go see what the Fifth Circuit does with this situation. So when we went and argued the case, we offered them 2 paths. One we said is, look, this final judgment offends Article 3. Like, it can't be that there's an internally inconsistent final judgment. Vacate the final judgment and ask the district judge to pick one of the arbitrators. Or, and as an alternative path, and this comes out of my deep love for the Lord of the Rings, I said there ought to be a final arbitration to rule them all. And so let's do one more arbitration that picks which of these arbitrations is the correct one. So the opinion came out about 10 days ago, almost 2 weeks ago. The opinion affirms the final judgment, but then says there really ought to be a final arbitration.
To rule them all.
To rule them all. They don't quite say that. Judge Jones apparently is not a Lord of the Rings fan. And the court says, I think there ought to be, these are internally inconsistent. There should be this final arbitration. So that's one thing to take away from this case. I don't think that has ever happened before in an arbitration proceeding. The other point to take is that the court's opinion identifies a clear and deep circuit split about class arbitration. 4 courts of appeals have held that if you merely incorporate the rules of the American Arbitration Association, you are consenting to class arbitration. And you're consenting to delegate that question of class arbitration to the arbitrator. 4 courts of appeals have held exactly the opposite, that if you want to choose class arbitration, you need to say we consent or we delegate class arbitration to the arbitrator. And the reason is there's a Supreme Court opinion called Lamps plus v. Varellis that says, look, class arbitration is extraordinarily different than bilateral arbitration. There needs to be a heightened standard for getting into that. And so the Fifth Circuit opinion identifies the circuit split, and obviously we are going to proceed on that point and seek en banc reconsideration of that and see if it goes anywhere. But it's a fascinating case. I know commercial cases are not short circuits, usual grist for the mill, but I thought it was worth talking about.
So I have 2 questions. One is the final judgment. If it's the one to rule them all, will it get at the end of the story dropped into the volcano?
I'll have to put together a fellowship to take it. Maybe the appellate lawyer, who's my friend on the other side, and I will go together.
Got it. And the other question is, well, you should have had the arbitrator sitting in bank like the district judge. Although that would have, I'm sure, just caused even more bad blood than we saw in the Duncan v. Bonta. Yeah.
And who knows, maybe there will be a Supreme Court opinion to rule them all on this issue as well.
Right, yeah, keep your eyes open.
Well, with that, I think it's a really good note to end on. Thank you very much for being here with us to celebrate our anniversary, Rafi and Eugene.
Thanks for having us.
Yeah, thanks for having us. This was a lot of fun.